I'm a law I'm a law professor, which means I earn my living thinking, teaching, and writing about the law rather than swimming and winning gold medals. That's what I do for a living. Let me see if I can get this better. Okay, that's better, I think. Okay. So in my case, I specialize in early American law and history. What I thought I would talk about today is the Bill of Rights from a law professor's perspective, which is a little bit different than I think you're probably used to. I did look at some of the prior events where you had other people come in and speak, and they were more practical in their approach. I'm more intellectual in my approach, given what I do for a living, more about ideas and things like that. And so I'm going to focus on two things during my talk. One is a critique I published about a Yale law professor's famous book about the Bill of Rights. And the second is an article I published about Roger Sherman's handwritten draft of the Bill of Rights. A quick FYI, as everyone probably knows, the Bill of Rights comprises the first 10 amendments to the US Constitution, proposed following the often bitter 1787-1788 debate over the ratification of the Constitution, and written to address the objections raised by anti-federalists. The Bill of Rights amendments add to the Constitution specific guarantees of personal freedoms and rights, clear limitations on the government's power in judicial and other proceedings, and explicit declarations that all powers not specifically granted to the US Congress by the Constitution are reserved for the states or the people. James Madison shepherded the Bill of Rights through the first Congress, as he promised he would do during the ratification debate. Yale Law School professor Akhil Amar is one of the most celebrated constitutional law professors in America. His book, The Bill of Rights, Creation and Reconstruction, is one of the most famous books ever written about the Bill of Rights. And there is Professor Amar. Amar's thesis is that the founders did not enact the Bill of Rights primarily to protect individuals or minorities from the majority, but instead drafted the amendments to protect majority rule and state rights against a potentially oppressive national government. It is the Reconstruction Amendments, those enacted after the Civil War, principally the 14th Amendment, Amar insists, that reconfigured the Bill of Rights as a protector of individual and minority rights. That's his famous book. Amar spends the first part of his book, the creation half, trying to document historically his point about the founders' Bill of Rights, and the second part, the reconstruction half, trying to prove his point about the 14th Amendment. Although I agree with Amar that the 39th Congress was endeavoring to protect in the 14th Amendment the individual rights of the American people in general, and of the newly freed slaves in particular, I believe that he is wrong to suggest that the framers of the original bill were more Republican than liberal in philosophical orientation. I will attempt to explain why I believe this to be the case by considering, in increasing order of generality, the founders' conception of property, the Ninth Amendment, and political theory itself. Another quick FYI, Republican in the sense that I just used it, and in the language of legal history, is not a reference to today's Republican political party. Rather, it means collectivism and or communitarianism. Liberal is not a reference to today's Democratic Party. It means individualism and or libertarianism. So in this talk, it's good to be a liberal because that means that you're in favor of the Bill of Rights protecting individual rights. Because I have only minor quibbles with the Reconstruction portion of Amar's book, I won't say anything more about that portion here. And that's John Locke. Turning first to the founder's conception of property, Amar maintains that James Madison's ability to secure the protection of private property, a quintessential individual right, in the Fifth Amendment, was one of the few truly liberal components of the Bill of Rights. He writes, quote, following in the tradition of Charles Beard, many modern scholars have stressed the importance of property protection in Federalist thought. Both the Article 1, Section 10 Contracts Clause and Madison's now canonical Federalist 10 do indeed evince hostility to redistributive legislation. But we must remember that the Bill of Rights grew out of a marriage between Madisonian federalism and un-Madisonian anti-federalism. And many anti-federalists were suspicious of the aristocratical tendencies of the Federalists. Of the original 13 colonies, only Massachusetts had a just compensation clause in the state constitution in 1789. And Jefferson's famous Declaration of 1776 had spoken of life, liberty, and the pursuit of happiness, rather than life, liberty, and property. Property protection, it seems, was more central to Madison than to some of his contemporaries. Importantly, the Federalists were the founders who supported the ratification of the Constitution. James Madison was the leading Federalist. The anti-Federalists were those who opposed the ratification of the Constitution. And as I said at the outset, Madison appeased them by promising to get the Bill of Rights enacted. In addition to underestimating the importance of private property to the anti-Federalists, Amar fails to appreciate that to the founders in general, the pursuit of happiness was synonymous with property, when property is conceived in a broad sense rather than simply as the ownership of material goods. According to John Locke, and again, that's John Locke on the screen, and he was the libertarian political theorist on whom the founders most relied, and I'll say more about that in a minute. Property must be understood to mean that property which men have in their persons as well as goods. Locke added elsewhere that property involves men united for the general preservation of their lives, liberties, and estates. That Thomas Jefferson was listing only unalienable natural rights in the Declaration of Independence provides another explanation for the absence of the word property from the famous clause at issue. As Locke mentions in the second treatise on government, man is the creation and hence the property of God. As such, every man owes a duty to his creator to fulfill himself or herself as an individual. To satisfy this duty, every individual must strive to protect his or her life, must strive to freely control the course of his or her life, and must strive to achieve a good and happy life. Property in the narrow sense of ownership of material goods is certainly indispensable if man is to satisfy his obligation to his creator, to preserve his or her life and liberty, and to pursue his or her happiness. But as important as property is in this material sense, it is alienable. Life, liberty, and the pursuit of happiness are not, as Jefferson made clear in the Declaration of Independence. Finally, Jefferson was a wonderful writer. Life, Liberty, and the Pursuit of Happiness reads more appealingly than Life, Liberty, and Property. And that's the Ninth Amendment. And I think I heard that the young man who read it, his name was Joshua. I think I heard that correctly. And so the amendment that he read is very important for my talk. A look at the Ninth Amendment provides additional insights into the shortcomings of Amar's project. Amar couldn't be clearer about his reading of this forgotten amendment. He writes, the Ninth Amendment is said to be about unenumerated individual rights like privacy, the 10th Amendment about federalism, and the preamble about something else again. But look at these texts. All are at their core about popular sovereignty. He then says that the legislative history of the Ninth Amendment confirms his collectivist interpretation of its text. Here too, I believe Amar has gotten the story wrong. The Ninth Amendment provides, as it says on the screen, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. To me, this language means what it says. The amendment was intended to protect unenumerated private rights. This fact is made even more obvious when one considers James Madison's widely cited June 8, 1789 speech to the U.S. House of Representatives advocating the adoption of the Bill of Rights, and that's Madison there. And this is what Madison said in his speech. It has been objected also against the Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration. And it might follow by implication that those rights which are not singled out were intended to be assigned into the hands of the general government and were consequently insecure. This is one of the most plausible arguments I have ever heard against the admission of the Bill of Rights into this system. But I concede that it may be guarded against. I've attempted it, as gentlemen may see by turning to the last clause of the Fourth Amendment, in other words, to the Ninth Amendment. Okay, so that's an article about Roger Sherman and the Bill of Rights. Amar doesn't discuss Madison's speech, the one I just quoted. He, like almost every other scholar I've ever read on the subject, also fails to discuss the draft Bill of Rights written in Roger Sherman's hand that suggests, at least to me, that the Ninth Amendment was designed to protect unenumerated rights. The Sherman draft reads, quote, the people have certain natural rights which are retained by them when they enter into society. Again, the text, and it is important to point out here that Professor Amar claims to be a textualist, speaks for itself about the sanctity of natural rights. The Sherman draft leads to the final point I wish to make about Professor Amar's reading of the original Bill of Rights. He has gotten the political theory of the American founding wrong. As historians well know, scholars have been disagreeing for years over when republicanism replaced liberalism as the dominant ideology of American law and politics. And again, today, liberalism in our sense is a good thing because it's about individual rights. It's not Democratic Party liberalism of the 21st century. Amar doesn't discuss this issue directly. Indeed, his textualist orientation makes it seem irrelevant to his way of thinking. Although I reject, for essentially common sense reasons, for example, people are able to communicate with one another, the argument advanced by many proponents of the application of literary analysis to legal texts, that meaning cannot be extracted from legal texts, but can only be put into them. In other words, that the Bill of Rights means nothing and means anything. It is difficult to deny the more modest claim that text can be interpreted only in some context. And that context, as I argue at length elsewhere, is the natural rights philosophy of the American Revolution, a political philosophy that is far more Lockean liberal pro-rights than it is classical Republican collectivist. In essence, then, Amar is merely the latest in a long line of law professors on the left who teach at the nation's leading law schools. For example, Bruce Ackerman of Yale and Frank Michelman and Cass Sunstein of Harvard, who are trying to claim that the Republican revival in the American regime lasted far longer than even the leading historians on the subject appear to believe. And again, the Republican revival is anti-rights. It's not a modern Republican political party. At the end of the day, though, my disagreement with Amar's reading of the original Bill of Rights has little practical significance, at least as a matter of constitutional adjudication, which is Amar's primary concern as a law professor. After all, Amar acknowledges in part 2 of his book that with the passage of the 14th Amendment after the Civil War, the bill became the benchmark of individual and minority rights that most of us have always thought it was. As he puts it in the book's last line, quote, "From start to finish, this book has aimed to explain how today's judges and lawyers have often gotten it right without realizing why. For me, how one of the nation's most celebrated law professors got to where he got on the meaning of the Bill of Rights is an equally fascinating story and one well worth reading." I briefly mentioned Roger Sherman's draft of the Bill of Rights a moment ago. I want to go into more detail about it now for a few minutes to provide another example of what scholars do that perhaps make us different from what other people do, including with respect to the Bill of Rights. And that's Roger Sherman. Roger Sherman of Connecticut is arguably the most underappreciated, not to mention the most understudied political leader of the American founding. Sherman is the only person to have signed the basic American documents, the Articles of Association in 1774, the Declaration of Independence in 1776, the Articles of Confederation in 1777, and the US Constitution in 1787. In 1987, James H. Hudson, the chief of the manuscript division of the Library of Congress at the time, reported that he had discovered among the James Madison papers a draft of the Bill of Rights written by Roger Sherman. This document is the only original draft of the Bill of Rights known to exist. Though in Sherman's handwriting, it represents not his personal views, but the work of members of the Congressional Select Committee on which he served, charged with preparing a draft of the Bill of Rights from James Madison's initial proposals. The draft differs from both Madison's initial proposals and the final version finally adopted that the students read, and these differences provide material increasing our understanding of the Bill of Rights. And so that's the draft bill, and it goes on for a few pages. There's the rest of it. And so now is something I sort of created in the article I wrote about this. And that's a table about Roger Sherman's draft that provides comparisons among the draft Bill of Rights written in Sherman's hand, Madison's proposals, and the guarantees included in the Bill of Rights as finally adopted. These comparisons provide some interesting insights, especially in light of the two winning student essays that were read. For instance, the free speech provision in the draft bill states that the people have the right to speak, write, and publish their views, quote, with decency and freedom. The decency component is not contained in the First Amendment of the Bill of Rights or in Madison's proposal, or for that matter, in any of the myriad state proposals the Select Committee had under review. Consequently, the draft bill appears to be more restrictive of free speech than the others. In practical terms, pornography and other speech considered, quote, offensive by many, but protected by the US Supreme Court, would likely be prohibitable had the draft bill version been adopted. The placement of the free speech guarantee in the First Amendment of the Bill of Rights, but relegated to the 8th article in the draft bill, is also interesting. If the placement of a particular guarantee says something about its importance, and there is no reason to suspect that it does not, then the draft bill does not appear to be as concerned as the adopted Bill of Rights is, or as Madison was, about protecting the press. This interpretation is consistent with the draft bill's more restrictive approach to free speech generally. The draft Bill of Rights also contains some provocative word choices that might have affected the scope of particular individual rights guarantees. For example, the draft bill's free press provision declares that Congress shall not, quote, restrain the press, whereas the Bill of Rights that was enacted uses the stronger word abridge. Perhaps more importantly, though, the draft bill contains almost none of the criminal procedure guarantees that comprise such a large part of the Bill of Rights, not to mention of Madison's proposals. The draft bill says nothing about search and seizure, double jeopardy, self-incrimination, speedy public trial, cause and nature of accusation, confrontation, witnesses, and counsel. In fact, the draft bill does not contain a due process guarantee. Here, Sherman's personal influence on the draft is suggested. That is to say, the absence from the draft bill of the protections afforded to those accused of crime that we take for granted today was not, it can be fairly said, because those working on the draft were unconcerned about these protections. Rather, it likely reflected Sherman's common law experience in Connecticut, both as a citizen and in his 33 years on the Connecticut Superior Court. In Connecticut, the courts were, as the leading authority on 18th century Connecticut puts it, quote, free to articulate and protect that whole range of liberties which could not be precisely defined in abstractions committed to paper. Consequently, under a common law approach that, like that followed in Sherman's Connecticut, judges would likely be more activist in criminal procedure matters than they are today. This provides a good example of why scholars and judges should refrain from interpreting the Bill of Rights and the Constitution simply through James Madison's action. In short, as the discussion of the protections afforded to those accused of crime reveals, when we interpret the Bill of Rights from a non-Madisonian perspective, say from the Connecticut experience of Roger Sherman, a quite different set of conclusions might come to mind. To mention one final example that I mentioned briefly in my critique of Professor Amar's book about the Bill of Rights, Sherman's draft sheds light on one of the most vexing modern debates in constitutional interpretation: the debate over whether the Bill of Rights has natural rights content. And as you probably know, natural rights are those rights that are not dependent on the laws or customs of any particular culture or government, and are so universal, fundamental, and inalienable that they cannot be repealed by human law. Most scholars maintain that the Bill of Rights does not contain natural rights content. However, a credible argument can be made that the draft bill makes explicit, quote, "the people have certain natural rights which are retained by them when they enter into society," close quote. What the Ninth Amendment leaves implicit, quote, "the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people," close quote, about the natural rights content of the Bill of Rights. Indeed, the Ninth Amendment's intended protection of both unenumerated positive rights and unenumerated natural rights is evident in Madison's differentiation in his June 1789 speech between the pre-existing rights of nature, or natural rights, and that's his language, and rights resulting from a social compact, or positive rights, and that's also Madison's language. Of course, the draft Bill of Rights, written in Roger Sherman's hand, was not adopted. But legislative history can help inform the interpretation of the text of a document, that is, including the Bill of Rights. Even the late Antonin Scalia, the leading textualist on the Supreme Court during his time there, acknowledged that where the plain meaning of the text is unclear, we should turn to history to uncover the meaning of the Constitution. In short, the Constitution, including the Bill of Rights, is the end product of various and varied proposals, debate, and deliberation. The discovery of the draft bill is therefore important, both because it provides insights into Roger Sherman's contributions to the Bill of Rights, and because it has something to say about what the Bill of Rights that was adopted means. And so with that, I will stop and simply say thank you for listening. And if you have any questions or comments, I'm happy to take them.